Well, hello everyone, and welcome to week 2. This is your week 2 Monday morning breakfast bite. And this week we are going to be studying chapters 4 and 6. 4 has to deal with common law, statutory law, administrative law. I'm going to talk real quick about the breakdown of that. And chapter 6 deals with dispute resolution. We'll talk about what that is also. And please do take a look at the PowerPoint for this week, because everything's laid out with regard to the manner in which we address and going through the materials. Now, before I go ahead and get into the substance of the material, I do want to talk about your assignment this week, because this week we're actually going to begin your brief writing assignments. And I've broken down the brief writing assignments into facts, issue, law, holding, holding law, and rationale. And that means that what I want you to do is I want you to take each section of the case brief, and we're going to address it just one section at a time until we take the whole case and put it all together in a case brief. And the case that you're going to be looking at is an interesting case because it's the Gonzalez versus Raich case. And it actually has to do with two people that had a medical condition where the only way they could get relief was by the use of medical marijuana. So it's really about their right to obtain the medical marijuana, because you have a state law that conflicts with the federal law, and it's just a very interesting approach. And look at the time frame when that case was being heard, because if that case were being heard today, I think we probably would have a completely different result. But it's an interesting case. You've got the excerpt from the case, and that's what you're going to be looking at. And you're going to be reviewing this case over the next few weeks, and we're going to be pulling different things out of it. For this week, all you're going to be focusing on are the facts. And I want you to realize that when we talk about the facts, we're not talking about how the case is set up. We're not talking about that. We're not talking about the procedural posture of the case. In other words, what happened at the lower court and how the case was appealed to the higher court. We're not talking about that. What we're talking about is what were the circumstances that caused this case to even go before the court. So what were the circumstances that occurred? What happened to Gonzalez? What happened to the other individuals involved? What happened to Raich in this? What happened to these people that caused these people, Raich and the other individual, to sue on behalf of themselves in order to say that what you were doing was a violation, government, of our X rights? So you have to look at the circumstances, and the circumstances are those things that we can prove with evidence that's presented before the court. So you want to make sure that you understand that. So when you look at the facts, look at the circumstances that led the individuals to be arrested or to have their products seized, and how that actually came about. So that's what we're talking about when we talk about facts, and I want you to focus on those and make sure that you don't generalize the facts. In other words, don't lump the facts together into a particular category. When you're talking about the facts, you have to be as specific as possible with them. And this is the one section of a case brief where you really are almost having to plagiarize the facts, because while I don't want you to cut and paste the facts and put them directly into your facts section, what I do want you to do is pick out the relevant facts, but you can't change them, so you have to be very specific with them when you're stating the facts. So in other words, if you're talking about the conditions that each person have, you don't want to say that both individuals had medical conditions requiring them to use medical marijuana. Well, that's a generalization. What were their medical conditions? What did the doctor say? What was it that was prescribed for them for the use of medical marijuana? What happened that caused the plants? Were there plants that were seized? What exactly took place that caused Raich and the others to feel that they should file suit? Okay, so that's what we're talking about when we talk about the facts. You have to be specific with them. Okay, so the Gonzalez and Raich case are actually provided for you in the homework section right above the case brief drop box. So you've got that there. Now I want to talk about the materials for this week, and I'm going to go ahead and click real quick on our PowerPoint. I want you to understand that when we talk about different types of law, we have our constitutional law, we have our statutory law, and we have state-created law. But in addition to that, we have what we call administrative law. So I want you to understand that the breakdown is you've got our U.S. Constitution, and that is the highest law of the land, right? Or, yes, that's still the highest law of the land. Then we have our statutory law, and the statutory law is developed by our federal legislators, or by our state legislators. So that is how the statutory law is created. But under the statutory law, you have administrative law, and of course then you have common law as well. But administrative law is very, very important, because administrative law is what the agency develops. So when you talk about administrative law, you're talking about agencies which are arms of the government that create laws that support the statutes. And so when we talk about administrative law, we're talking about the Internal Revenue Service is an administrative office of the government. The Environmental Protection Agency, the EPA, is an administrative arm of the government. And what these administrative arms do is they not only help with enforcing the law, but they also actually create regulations that help give clarity to the statutes, because statutes are written in a very broad sense. And when they're written in this very broad sense, it's hard to follow it and enforce it because it's so overly broad. Regulations come in and they help to define what was meant by the statute in order to allow law enforcement and the courts to be able to actually enforce the statute and the statutory intent. So that's very important to understand. Case law is what happens and what's developed once the court system gets a case in, and then based on the facts of this case, the court says that either the facts actually coincide with the law and apply to the law, or the law doesn't apply to this particular set of facts or circumstances because it doesn't meet the elements of the law. So that's what we're talking about when we talk about the different types of law. And I know this is very quick in a nutshell, but when we talk about alternative dispute resolution, that's very, very important, because with alternative dispute resolution, we're talking about different ways of reaching a settlement or reaching the resolution of the case outside of court. And there are different methods. There's negotiation, mediation, arbitration. You never ever want to agree to binding arbitration, if at all possible. And if you remember nothing else from this course, please do remember no to binding arbitration. Now, can you always say no? You can't always say no, but when you're signing a real estate contract and it states on there binding arbitration, X through it, put your initials on it, say no, I'm not agreeing to it. What arbitration does is it takes, binding arbitration in particular, takes your right away from going to court and suing. And if you have a choice between arbitration, binding arbitration, or court, you want to go to court. You always want to be able to go to a courthouse rather than arbitration. The rules of evidence are more relaxed in arbitration. It's just not the same, and you don't have a judge ruling on your case in binding arbitration. Non-binding arbitration has no effect. It's really more like a negotiation or a settlement, but what it does is it is a formal way of presenting your case and giving each side an idea of what would happen if you were to actually go to court on it. But it's not binding. So no to binding arbitration. Negotiation is very informal and a great way to reach a settlement, and that happens between the parties or between the parties' attorneys, and just in that manner. It could be letters back and forth, it could be telephone calls back and forth, it could even be a settlement conference with just the attorneys and the parties. But that is a very relaxed form of settlement negotiation or dispute resolution. Mediation is more formal. What happens with mediation is you actually have a certified mediator who tries to get the parties to reach a resolution. And you generally will go to the mediator's office, both parties with their attorneys, and you will meet together in a room initially, and then you'll separate into what we call caucuses, which means one party will stay in the meeting room and another party will go to another office. And then the mediator goes back and forth between the parties to determine, to try and get the two parties to reach a resolution. I will tell you this, I was a trial attorney for a long time. Whenever you can settle a case outside of court, you're never going to run out of the mediation or be, waving your hands and say, "Woo, I won." That's not the point. The point is that you settled your case without having to have any more heartache, aggravation, lost time from work, lost time from your business, and expense to keep going with the case. You've settled it, and the parties have reached a mediation, a medium point. You've reached a resolution, and somehow you've met 50-50, and you're satisfied with the outcome. You're not elated with the outcome, but you're satisfied because at least you know it's done, it's over, you've reached a resolution. The defendant's coming out of pocket with some money, and the plaintiff is getting money as well. So that's what we talk about when we talk about dispute resolution. The last thing I want to hit on, and it's very, very important, so please do look at the PowerPoint, is jurisdiction. Jurisdiction is very, very important to any case because jurisdiction is divided into different types of jurisdiction. There's in personam jurisdiction, there's in rem jurisdiction, and there's subject matter jurisdiction. Those are the primary forms of jurisdiction. There's also something called quasi in rem, but we're not going to talk about this. We're just going to talk about in personam, in rem, not so much, and subject matter. Now, in rem is jurisdiction over the person, the parties who are involved in the case. I'm sorry, in personam is jurisdiction over the parties in the case, those individuals who are actually the plaintiff and the defendant. Subject matter jurisdiction is jurisdiction of the court to hear the case, the subject of the case, whether it's a slip and fall, whether it's a negligence case, whether it's a criminal case, whether it's a breach of contract. That's the subject matter of the lawsuit. And the court must have both subject matter and personal jurisdiction in order to hear any case. If either of those are lacking, then the court cannot hear the case. In rem jurisdiction is jurisdiction over the property, and that comes into play when you have immovable objects. And so in rem jurisdiction isn't something we're going to run across every day, but it can be an issue. It attends to real estate, real property, it attends to fixtures to real property, and it attends to things that are not movable. Say a ship gets stuck or their cargo is somewhere. It's those types of things, and sometimes that happens on an international basis as well. So it's important to understand that in order for a court to hear a case, the court must have personal jurisdiction and subject matter jurisdiction. It's also important to understand that in order to assert personal jurisdiction, a court must have a state long-arm statute that allows them to do that if it's in a state court, and that by utilizing that long-arm statute, you're not offending notions of fair play and substantial justice, which is basically due process. So there is a formula that you have to look at, and there is a test that we have to look at in determining whether or not there is jurisdiction in a particular case. And I state that in the slides under jurisdiction and due process. And for due process, I state that there is a two-pronged test. First, you look at one, whether there's minimum contacts. Minimum contacts in a state doesn't mean somebody has to necessarily have been present in the state. It depends on the lawsuit involved. But if you have minimum contacts, then you go to the second prong, which is, will the exercise of jurisdiction offend notions of fair play and substantial justice? If no, you're good to go. So you have to go through this analysis in this process. It's different with cyber law and in cyberspace, but you have to be aware of these things. It's very important. Now, I know that this has gone a little over 10 minutes, and I try to keep these to 10 minutes or under, but hopefully it's giving you some good information. So this week, you do have some things on your plate to look at. We do have, oops, where did I go? I lost some of my information. For your homework, you have your week 2 discussion, you have the case brief part 1, just the facts, and you have quiz 1. Now make sure you label your facts with facts, okay? So let's see that title, facts, on your submission, and then you have your colon, and then you go ahead and you list what those facts are. Use proper paragraph structure, okay? Don't forget that. Use proper sentence structure. Under no circumstances is bullet pointing allowed in the facts. So if you do bullet point, you're going to get a significant reduction in your grade if it's graded. So, proper sentence structure, proper paragraph structure. If you have any questions, please, please, please don't hesitate to contact me. And you guys have a great week too.